It's February 16, 2024.
Perfect. Thanks. Yeah, please. I want to take one the other bit.
Good morning. For the record, today is Friday, February 16, 2024. This is the West Roxbury Division of Boston Municipal Court. Presiding today in the third session is the Honorable First Justice County. All right, good morning, everyone.
Sure.
Any changes to the clients here?
They're right outside or just coming in. She actually wants to speak with you for just a second. May I?
Of course. Of course.
Oh, one.
Thank you. Commonwealth versus Catherine Vitale, 590. Commonwealth versus Shannon, Llewellyn, CR 593.
Good morning, everyone. Thanks.
Good morning. All right, what would you like to do today? I have received your third supplemental memorandum regarding selective prosecution discovery. I reviewed it.
Okay. That actually is kind of a work in progress because the balance of the defendants on some of those matters were scheduled for Tuesday. It was a snow.
Right.
So we'll follow up and have a slight amendment just so that the court has complete records on everything that's submitted. The other thing is, I have another file today that I served on the Commonwealth regarding the discovery status from the Commonwealth. Now, I haven't received anything thus far. I had a conference yesterday with Kelly Ryan, who is the supervising DA in this court, and she informed me about ongoing efforts to obtain this discovery. I'd like to file this today, and if we don't have that discovery by the next day, then the court might consider what us file and the potential remedies that are seeking. But I'm trying to give the Commonwealth every opportunity to fulfill their, well, to essentially comply with court's order. So if I may I file this?
Absolutely.
What that contains within, which is noteworthy, is that the exact same discovery that this court has allowed was allowed downtown. But the discovery responses there, well, are somewhat in conflict.
We're allowed downtown for what types of cases?
For another dissolution type of case. Another protester is, it's actually, he has two cases. One is a vaccine case. The other one was just a straight out protest case at City Hall. And there's a divergence in the responses that the district attorney's office and the BMC is giving from what I'm getting here, so we need to sort that out.
Let me ask you the obvious question. Because we've had several court appearances. Have you and the Commonwealth discussed resolving the case, or are your clients looking for a jury trial?
Well, we've been looking before there was a jury trial for this motion here that I'm working on, potentially dispositive in and of itself. But leaving that off to the side, there's never been any discussion of a disposition, although I'll state in open court that my clients would take the dispositions that have been offered to all the other protesters, although it's a little bit too late for that because...
Arraignment has already taken place.
That's right.
Okay. Recognizing that, we can't unring the bell, so to speak. would that be fruitful, or do you
Well,
want to
it
continue?
potentially could be, because, I mean, the Commonwealth has the power to shut me down entirely with what I'm doing, just by dismissing these cases.
Right.
Obviously, they're taking a position that, well, they don't want to do that. I would submit that for the same reasons that there's this great disparity between how some protesters are treated versus others. But that's just me. I haven't put together my proof yet, but I'm well on my way. And so if you want to know what my target is, I've always targeted between 150 and 200 cases.
Well, when you say targeted, it probably another, your resolution, how you would like to see the case.
What I think is sufficient proof. I'm up to 154 right now. I'm well on my way to finishing that part. I have a compendium of statements, not all of which I've submitted to you from the district attorney's office, which I think go to intend and resolve with regard to this matter and other matters. And the final thing is the discovery from the Commonwealth, because I would like to have a full comparison of the type of protesters who are protesting the subject matter that these defendants who are protesting versus, well, the lack of better word, approved protesters. There seems to be an element of approval of protesters, against racial matters or climate change or LGBTQ, even when they commit felonies.
Okay. Do you care to respond? You need not, but do you want to respond?
With respect to which point?
Resolving the case in some way.
If the defendants wanted to tender pleas, I could certainly come up with a recommendation. There, as Defense Counsel said, there's been no discussions as of yet as to that matter, but I'm happy to have those discussions.
Okay. So what shall we get done today?
Well, I think we can schedule the next date to deal with this issue here. I mean, the court ordered apparently a discovery, not all of my requests, but certainly a portion of it, and I haven't received anything. It's noteworthy that with regard to some of the requests that this court has allowed, the district attorney's office in Boston is objecting on the grounds of work product.
But quite frankly, that's not my concern.
Well,
What happens in...
understood, but it would become a concern if,
We can only address what is in front of us.
yes, I'm just concerned that we may ultimately get that as the response to some of these requests.
All right. So did you I know you just filed it with the court. Previously, had you given a copy to the Commonwealth?
Just this morning.
All right. So what they would like then?
Before we pick a date, Your Honor, if I may file a notice of discovery with the court and Defense Counsel. That notice of discovery memorializes the Commonwealth's efforts to comply with the court's order to produce the quote master list of protesters. And I have additional information that I just found out maybe about 10 minutes ago and wasn't able to type up in that. Essentially, what the Commonwealth has done is first reach out to the Office of the Legal Advisor. They had no information about any master list of protesters. They recommended contacting District E5 directly. Which I did. I contacted the highest ranking officer named in the police report, who is still employed with BED.
And who's that?
That's Sergeant O'Brien.
Who's that guy?
Then
I'm sorry.
she's correct. He's not the highest ranking in E5. He's the highest ranking name I could see in the police report, and he was directly involved.
Attorney Jens, could you?
I object to what he's saying, it's a lie, he's the lowest ranking person in that.
I'll get an opportunity to respond. Thank you.
Thank you.
It was mostly patrol officers mentioned aside from the sergeant, so I contacted him. He said he thought that the master list might have referred to a compilation of booking sheets and applications for clerk magistrate's hearings on city ordinance violations relative to incidents of targeted protesting. He's informed me that's something that had been previously provided to the Commonwealth, but I looked through both of our files for these two defendants as well as the files for the other two defendants who were charged contemporaneously but whose cases were null-pros back in August of 2022, and I couldn't locate anything like that. It should be possible for him to essentially recreate that packet of materials. ADA Ryan was also able to talk to a higher ranking official, Lieutenant Kern at District D5, about the possibility of looking through now former Captain Greeley's email. And what we learned is that when an officer leaves BPD or retires, their email account is deactivated and it's not accessible by other officers. Potentially accessible by the IT department, although that seems to be speculation on Lieutenant Kern's part. And then just this morning, ADA Ryan spoke to Lieutenant Kern again. He and Sergeant O'Brien had spoken, and it does seem that their conclusion, without having the benefit of being able to talk to Captain Greeley, is the master list of protesters that he's referring to in that email is a just compilation of various booking sheets and clerk magistrate hearing applications for individuals arrested for protesting activities around that time, I would presume, although I don't have a precise time frame or geographic scope aside from, I assume, things that happened in E5. We can request from Sergeant O'Brien those materials again, and I don't know if he has them readily saved anywhere, but it's possible he could recompile that. All of that is to say, from everything we've learned, there doesn't appear to be like a Word document or a handwritten list or anything like that.
Okay, would you memorialize what you just said, put it in writing?
Yes, most of that is memorialized in that discovery notice. I can file a supplemental one relative to what ADA Ryan learned from Lieutenant Kern this morning.
Okay.
Your Honor, we addressed this subject concerning Sergeant O'Brien's conclusion in our submission to you that I just gave you.
Okay.
And his statement that the master list represented a compendium of police reports or whatever for those summons in connection with alleged violation of the city of Washington ordinance against targeted protest. It just can't possibly be true. Here's why. That original email that was given in response to Judicial Watch's FOIA request was dated April 4th of 2022. That's right on the heels of the passage of the ordinance in the first place. No one had been arrested for it by that. No one had been cited for it by that. So it obviously was pre-existing based upon some sort of protest activity apart from the ordinance. And I developed that in our submission, which, you know, I invite the court and the Commonwealth to scrutinize so that we can have a meeting, we can approach this in a more meaningful way on the next day.
Yeah, and I actually agree with that. I think defense counsel is correct. My first reaction was in Sergeant O'Brien's response was a bit of confusion because naturally the arrests in this case post-dated the email from Captain Greeley. So if there was a list of protesters, it couldn't be just the booking sheets and arrest forms from this series of arrests. And what I think it must be is, again, I wish I could define the scope of it, but I just don't have that information right now. Some compilation of booking sheets relative to crimes committed in the midst of protest activities in District D5. I can contact Sergeant O'Brien and try to identify the scope of that, but right now that's the only information I have.
Okay. What day would you like?
Could we use a partial to Fridays? and I hope the court is too. Can we use March 8th?
Is that convenient for the court?
Say March 8th.
Yes.
Yes, that should be in the matter.
Excellent. At your request, then, March 8th.
Thank you so much.
Okay.
Why does he get 5 months to do this? Why is he getting more time? Why should not define? This is I object because I asked my representative today to define what the master list is. It's been month after month after month. This is an undue hardship to my family for me to present myself every single time. And no, I will not take myself behind the screen or not show up. This is an undue hardship. It's 5 months of playing games.
Thank you, ma'am.
With our life. Thank you. No, it's not thank you.
Party present matters continue March 8th for further trial. Okay.
I'm sure the court is noting the defendant's objection.
Yes.
Thank
Thank
you.
you.
Thank you, Madam Clerk. Yeah.
All rise, please. What's in recess?
That was just.
Yes.
Thank you.
Five,